The meeting will come to order, please. We are on the air. A warm welcome to you all on behalf of the Adlai Stevenson Center on Democracy. And a very special thanks to Robert Stewart and the Stewart Family Foundation for its generous support of this luncheon meeting. A very special thanks also to the renowned Senator Russ Feingold, from whom we will hear shortly, founder of Progressive United, and Trevor Potter, who among many distinctions leads the Campaign Legal Center. He's a fighter for effective campaign finance laws. By way of introduction of the subject matter, I want to recall just a couple of vignettes from my book, the Black Book, which records American politics as my family knew it, going back 5 generations to Abraham Lincoln. Great-great-grandfather Jesse Fell proposed the Lincoln-Douglas debates, 7 of them, 3 hours each. People came miles and miles and miles on foot and by horseback and by wagon to be a part of their politics. Those debates brought Lincoln to the nation's attention. Without Jesse Fell, the citizen, there might never have been Abraham Lincoln, the president. Now let's jump forward to 1948. The Democratic Organization of Illinois gathered here, behind closed doors, of course, in Chicago, to nominate for governor a New Deal bureaucrat, an architect of the United Nations, of all things, here in the center of American isolationism, a senior official of the Truman and the Roosevelt administration for governor, and for the United States Senate, an eminent professor of economics from the University of Chicago. Also, a reform alderman of the city of Chicago City Council. Now, that's an oxymoron. I can. They campaigned day in and day out, pressing the flesh. I was the driver. And when it was all over, my father had won the governorship by the largest plurality, the largest margin in the history of Illinois. His campaign cost $154,000. I don't remember a fundraiser. He reformed Illinois. Senior officials didn't pay to play. They sacrificed to serve. In 1952, he was drafted for President of the United States at the convention here in Chicago. He didn't enter any primaries. He started that campaign with no money, no staff, and no program, and went on to electrify the world. He was renominated after 5 primaries, contested primaries in 1956. In the elections, in those campaigns, he started the strategic arms limitations process. He laid down the programmatic foundation for the New Deal, for the new frontier and the Great Society. Democracy was not simply a system for acquiring power. It was a system for informing the people so they could make a sound judgment. He said, trust the people. Trust them with all the truth. What wins is more important than who wins. I'm glad he's not here to see our politics today. As the complexities of government in a dynamic, interdependent, multipolar, nuclear world have mounted, our competencies have declined. The Adlai Stevenson Center, housed at the family home near Libertyville, now owned by the Lake County Forest Preserve, district, brings practitioners from around the world together to address systemic weaknesses in democratic systems and produce practical answers. It aims to restore American values to American politics and America to its rightful place in a world at peace. With us to moderate the discussion of our polluted politics is someone famous to you all and a dear friend, Elizabeth Brackett. She's known to you as a correspondent for WTTW's Chicago Tonight, as winner of many Peabody and Emmy awards. She was formerly with the McNeil-Lehrer NewsHour. She's author of Pay to Play, How Rod Blagojevich Turned Political Corruption into a National Sideshow, and more. It's a personal privilege for me to give you Dibby Brackett. Thank you.
Thank you very much, Adlai. Thanks so much. I'm delighted to be here this afternoon. There's no topic that really is more important in the midst of a campaign season than what money is doing to politics. It's a topic that we really don't cover much, I have to say. When you look at the way campaigns are covered, the way we cover money usually is how much the candidate has raised or how much the unrelated super PAC has raised for the candidate. So I'm pleased to finally have what I know will be an informative and productive discussion about the influence of money in politics. And as you can tell from the title of my book, Pay to Play, there probably is one. And joining us now are two people that we couldn't have two better guests to discuss this topic. First, Senator Feingold, who, as someone said this morning, Illinois often claimed him as our senator too, even though he was senator for 10 years from Wisconsin. We're delighted to have you. And then Trevor Potter, who probably knows more about campaign finance reform than anyone in the country right now. He was a former the chairman of the FEC, as well as a member. He was also the chief counsel for John McCain's presidential campaigns. But if you want to know why, if anybody in the country knows much about campaign finance reform and Citizens United, it's because he's also the counsel to Stephen Colbert, who has explained more about campaign finance than I think anyone else in the country. So with that introduction, let's start off with Senator Feingold and hear what you have to know about campaign finance reform.
So thank you for all your good work here. I want to thank the Adlai Stevenson Center for Democracy for what you're doing and creating this wonderful organization, and the Stewart Family Foundation for your making this all possible. I want to particularly thank Senator Stevenson. You know, as I told you, in our family, the name of your father, Adlai Stevenson, was simply revered. We had Adlai and Estes buttons all over the house. And one of the great prides of our family was that my uncle was a rabbi from Chicago, a man named Louis Binstock of Temple Sholom. And one of the great honors in our family was that he gave the invocation at one of those Democratic conventions that had the wisdom to nominate Adlai Stevenson to be President of the United States. So it means the world to be associated with you and your family, and I followed your career, and you were a model for me as I listened all the way from Janesville, Wisconsin on News Radio 78, which was, I was addicted to it as a kid. So it is wonderful to be with you. And it is a thrill to be with Trevor Potter. You know, when you do a piece of legislation as complicated as McCain-Feingold, there are so many people and organizations that are a part of it. But there were 6 or 7 people who really did the most and were involved every step of the way, brilliantly so, in the case of Trevor Potter. We would not have our law in place had it not been for his good work, and it's a pleasure to appear with you.
Thank you, sir.
In fact, I'm going to do sort of a history of campaign finance, history of the world, part 1, but not Mel Brooks style, in 8 minutes.
You have 5.
I have 5. I will do it in 5. I was told when I wrote my book that what you should do is start off the story sort of in the middle, show, don't tell. So I'm going to say, start with McCain-Feingold, which of course just passed a few years ago. Imagine that McCain-Feingold was a brick that was put in to replace a brick on a solid brick wall. A hole had developed, And we saw a loophole and we wanted to close it, but it was built on a solid foundation. What was that foundation? The foundation were the laws that were passed after the Gilded Age, when the robber barons were dominating this country and the oil industry and the livestock industry. People finally said they had enough. And in the Great Progressive Era, they passed legislation to deal with these problems. The Sherman Antitrust Act and others that are well known, but also the Tillman Act, signed by Theodore Roosevelt. Tillman said corporations can't use their treasuries, the money that you spend on toothpaste or detergent, for political campaigns. That was the law of the land since 1907. In 1947, people said, all right, what's good for the goose is good for the gander. If corporations can't do it, unions shouldn't be able to do it from their mandatory union dues. That was a provision of the Taft-Hartley Act. No one ever suggested to me, until the Citizens United case, that that wasn't good law. When I went on your friend's show, Stephen Colbert, he said, what's your problem, Russ? Do you hate corporations? He said, when you see a corporation walking down the street, do you cross the street? Will you let your daughters date a corporation? No, I don't hate corporations. I just thought the wisdom of the country was that corporations and unions shouldn't be able to do this. McCain-Feingold just said, look, they can't do it indirectly through the political parties through soft money. We passed it. It's the law of the land. It is still the law of the land. But the brick wall below it was completely smashed by Citizens United. And now you have a lawless decision and a lawless political environment that would shock anyone who cared about this issue, from Adlai Stevenson to John Gardner to you name it. It has to be turned around. We'll be discussing that. But that is what happened. It was not business as usual. It's not the way it's always been. In 2006 and 2008, McCain-Feingold was in place. Couldn't do unlimited contributions. Citizens United hadn't occurred, so what did people do? They turned to democracy, electronic democracy, internet contributions from students and people who were 90 years old and others who had never felt that they could participate. And what I believe is the corporate powers in this country saw the face of democracy and they were terrified. And so the Supreme Court did something terrible to our democracy that has to be reversed.
Trevor Potter, does it have to be reversed?
Well, first let me say it's a great treat to be back in Chicago. As a native Chicagoan who has gone astray and headed east, it's always good to be back. I don't think I've ever been in quite as grand a setting before in Chicago, so I like this. I am in the presence of two of my heroes today. Ambassador Bob Stewart of the Stewart Family Foundation, who has given us lunch, has also given us leadership on this issue for many years. And it's leadership that has meant a lot to me because I'm a Republican. And for some time, there has been a question as to whether one can be a Republican and still think that campaign finance reform makes sense, that there ought to be some limits to the way money is spent in politics. And Ambassador Stewart, a former Republican National Committeeman, has led the way in the party up to opposing soft money, to fighting for McCain-Feingold. And we need Republican voices like that, because if we're going to do something about the current state of money spent in federal elections, it's going to have to be bipartisan. It cannot be a one-party prescription. And it was the bipartisanship that Russ Feingold showed in reaching across the aisle and working with John McCain that made the McCain-Feingold law possible. So I think both of you have demonstrated leadership that we sorely need now, when there is less bipartisanship in Washington than certainly in my memory. In terms of what the Supreme Court did in Citizens United and where we go from here, I heard on Monday Senator McCain speak. He's been quiet for a couple of years on this, I think, frankly, because he really felt betrayed by the Supreme Court. He had done the hard work of passing a law. He had seen it upheld in a 5-4 vote, and suddenly the court, with a change of one justice, pulled the rug out from underneath him and was finding the principles upon which the law was based, and which we'd had in effect for roughly 100 years in this country, in terms of the ability to limit corporate and, as Russ has explained, union money in elections. Suddenly we were told those principles were wrong by one vote. And I think Senator McCain thought, well, I'll spend my time doing something that's more profitable unless there's a change in the court. But as he looks at what's happening this year and the money being spent and the rise of super PACs and all the rest of it, I think he's getting his voice back and his dander up. So his comment the other day was that he thought Citizens United, the decision by the majority, was a combination of arrogance, naivete, and stupidity, the likes of which he had never seen before out of the Supreme Court. And it worries me because I think he has put his finger on something here that we as a country and as a democracy are going to need to think about a little. This is the first Supreme Court in the history of the United States of America since the adoption of the Constitution which does not have a single justice who has ever served in elected office. We started with a Supreme Court which had former government officials and former senators and former governors. You look back on the courts we have known, and they were led by former governor of California, Sandra Day O'Connor, who was the key vote in McCain-Feingold, was a former Republican leader in the Arizona legislature before she became a state judge. These were people who understood what the other branches of government were doing. They understood how politics worked, how fundraising worked, how legislation was drafted, and specifically in O'Connor's case, I think she understood what Congress was after, which was the danger between large sums of money spent or threatened to be spent on elections and legislative results, which ought to be two different things. And so with the resignation of Justice O'Connor, we have lost the only justice who actually had been in the give and takes of politics and the legislature. And we've ended up with a court of distinguished legal experts. But the Constitution is more than just laws. It isn't legal theory. It is our governing document, and it has to reflect, I think, our nationwide values. And we have two values here that have some tension between them. Russ Feingold has been throughout his career a fighter for the First Amendment. And I think it is simply wrong to say that trying to regulate the role of money in politics so it is not corrupting, is not legalized bribery, doesn't buy legislation, that is somehow anti the First Amendment. My own personal view is that we had a pretty good balance before the case in Citizens United, where corporations could have PACs, but the money in it came from individuals and was limited in amount. Corporate executives, of course, were always free to speak their own mind as individuals, and corporations had a role, as did unions, in communicating with their members and shareholders, but there was a balance there. We've now lost that balance. And it's a problem for a democracy, because while we believe in free speech and the right of people to express themselves, we also believe in one person, one vote, that everybody is entitled to express their opinion. And can you have a one person, one vote democracy if you can have a billionaire with gaming interests in Macau who can essentially nominate or attempt to nominate a candidate by being the principal funder that keeps that candidate going in the race? And I don't know. Those are going to be hard questions that we need to look at. But as I move around the country, on both sides of the political aisle, I hear people who are deeply unhappy. They may have different solutions, but they don't like the place we are in at the moment, partly because of the Supreme Court and Citizens United, and partly because the whole regulatory enforcement structure of the Federal Election Commission has fallen down and isn't functioning. So those are a couple introductory thoughts.
Do you think that the Supreme Court, particularly Justice Kennedy, realized what the impact would be of Citizens United? And what indication have you seen from the justices themselves that this may have gone a lot further and acted in a different way than they thought it would?
Well, I attended the oral argument in Citizens United with John McCain, and we heard Justice Kennedy's observations sort of from the bench without any record about what he thought corporations were like and what they would do. And there was no basis for his conclusion about the nature of corporate activity. I like to think that he's a little surprised at what's happening. I don't take a cynical view of Justice Kennedy, and I do notice that recently, in considering the Montana case that may be coming through that could give an opportunity to the court to undo the damage, Justice Ginsburg actually wrote a comment, an opinion, which is rare, saying it's getting difficult, in effect, in so many words, to not take judicial notice that this is corrupting. And so that's a rare thing. And I wouldn't have said this 2 months ago, but I think there may be such turmoil and concern on the court right now that this is having the kind of effect that Trevor just identified as occurring across the country, that they may be worried about the institutional impact it's having on the Supreme Court, which of course began the previous decade with Bush v. Gore, one of the worst decisions in the history of the United States Supreme Court, finished the decade with this lawless decision in Citizens United. Now, if they put the cherry on top of this Sunday and strike down the health care law after 70 years, this is an institution in free fall in terms of its credibility and our belief that it's on the level. So I'm hoping those considerations will come into mind in addition to the specifically legal considerations.
Well, I think it's actually clear, to answer your question, that the court demonstrably got it wrong, that what we're seeing is not what they told us we would have. Because Justice Kennedy, in the part of his opinion which was joined by the 4 dissenters, so you had 8 justices, said, after this decision, we will have corporate money spent for the first time in independent expenditures and elections, and it will be fully disclosed so that shareholders will know and be able to act on that information, and voters will know where the ads are coming from, because that's important. It's part of the information voters need.
So tell us what is happening now instead.
What's happened is there are plenty of ways around that. The court was simply wrong in thinking that current law required full disclosure of all spending. Instead, as Mr. Colbert has had great fun explaining, there are lots of ways around this. You can give directly to a super PAC, and it's required to disclose its donors. You can form a shell corporation so that nobody knows where the corporation's money came from, and it could be one individual who creates this, and the XYZ corporation is listed publicly as the donor. It can be done through entities that don't disclose their donors at all, the so-called 501c4s and c6s, which are routes for people who want to spend money to affect elections but don't want anyone to know who they are to go through. So we don't have the full disclosure that the court said we were going to have. They also said that this would be independent expenditures, and in their case law that has meant spending that is wholly independent of candidates or parties. You just open the newspaper. This is not wholly independent of candidates or parties. It is money, in some cases, even being raised by the candidate. The principal funders are traveling with the candidates.
Well, how do they get away with that if it is so contrary to what the Supreme Court said?
The court can only deal with the law that they're given. And in the case of disclosure, I always check with the lawyer who knows more, but we tried to pass something called the Disclose Act after this decision because the court ruled 8-1. Only Clarence Thomas thought that there shouldn't be disclosure, that there couldn't be disclosure, but Congress still has to pass it. And last time I checked, Trevor, we're at 59 votes to break the filibuster on this issue. Is it that
probably fewer now?
Now, but I think there were votes where we had 59. So, if just a minor bipartisan effort to have disclosure were put into place, we could have that kind of a law. The other thing is we could pass a tighter law. I've talked to Fred Wertheimer about this. We could make a law that makes it tougher to get away, and Trevor's talked about this, with this phony notion that it's really independent. That's something that can be done statutorily, but you have to pass the law. The court can't just make it up.
Yeah, in some ways, we've hit this perfect storm. The Supreme Court issues Citizens United in an environment where Congress is deadlocked, gridlocked, and unable to act. I thought there was a likelihood that Congress would react by at least passing the disclosure legislation the court thought we already had, but they got bollocksed up in the usual partisan debate, and not a single Republican would vote for the Disclose Act. It lost by 1 vote as a result. The Republicans said, we weren't included in the drafting. This is a heavily Democratic-oriented bill, so they're trying to stick it to us, and we're not going to. There's a new one that's just been introduced by Senator Whitehouse, which I think is much less partisan in design, but there's still no evidence that there's going to be bipartisan support for it because Congress is split. And the enforcement agency, the FEC, is split. It was designed by Congress to require a bipartisan consensus to enforce the law. There are 3 Republicans, 3 Democrats, and you have to have 4 votes to do anything. So you have to be bipartisan. Well, that works as long as you have, as there was when I was there, a group of commissioners who are willing to act together. What we've ended up with is 3 Republicans and 3 Democrats who can barely speak with each other, and they don't have 4 votes for anything, basically including whether to call a meeting to order.
Tell us the last time they issued a decision.
They will issue decisions that are non-controversial, but every time you get to a key issue, is something coordinated, is disclosure required, they split 3-3, which has the effect of saying they can't do anything. So on the McCain-Feingold law, it says that every advertisement during the campaign period, whoever puts that on the air has to disclose their funders of $1,000 or more. Pretty straightforward, at least those of us who were involved with drafting it thought it was. Now that the FEC has interpreted it, which is to say that the 3 commissioners who don't like it have narrowed it in their view, they've said, we will only find you have to disclose if somebody gives you more than $1,000 and they say, this is to run that particular ad. Well, it doesn't happen in life. The ads usually aren't even created until after someone has funded it. So you have a donor who gave Mr. Adelson, the same guy who's funding the Gingrich Super PAC, gave tens of millions of dollars to a group called Freedom's Watch, which ran ads. It turns out he contributed 99% of the money to Freedom's Watch, but when they filed their disclosures, they said that there was no individual who had funded those ads at more than $1,000. I mean, how can you do that? And the answer from the 3 commissioners was, well, he didn't specify that his money was to be used for those ads. So we're in this tug of war that we need to break through, and it's going to require, again, I think, a bipartisan consensus that we need a better FEC. We need, if the laws are not being interpreted as they should, then Congress needs to go back and rewrite them and say this is what we meant, which is what the Disclose Act is trying. But it's very hard to do that in the current angry partisan environment we have in Washington.
You know, progressives and others always assume that large amount of money flowing to candidates equals corruption. But the other side, represented by James Bopp, who is the attorney for Citizens United, I heard him on Terry Gross, an interview with Terry Gross, and she was talking to him about the millions that Mr. Adelson had given to Newt Gingrich. And Mr. Bopp says, you are assuming that Newt Gingrich is corrupt, that his positions are up for purchase, and that because this person, who apparently agrees with Newt Gingrich on every single issue, would change his mind or change his position. There's absolutely no evidence that Newt Gingrich has changed a single position because of that contribution. And frankly, a person who is a fool who thinks to give money to somebody that disagrees with you in order to change that position is a good strategy.
Well, so it was a very good strategy in the 90s where we had both parties. You know, sort of my test of corruption is if you hadn't gotten the contribution, you would have voted differently. Well, there were an awful lot of corporate Democrats in the 1990s that put through legislation that never should have happened. The good way to test it is to look at votes that are 90-10. Try the trade agreements that shipped our jobs overseas, like NAFTA and GATT, where both Bill Clinton and Al Gore and Bob Dole and everybody was all for it because you might expect Republicans to be for it, but on the Democrat side, it was the soft money contributions that caused them to say, actually, we'll do this for these corporations and go against the unions and others who they normally would side with. Another great example, I think it was 92-8, Telecommunication Act 1996, the fantasy of consolidating the media in this country in a way that took away individual radio and other voices in our country. 92-8. Why were Democrats voting for this? Because of the huge contributions coming from the telecommunications companies. And if you don't think those are enough examples, try what happened on Wall Street. The repeal of Glass-Steagall, 90-10. Democrats voting to repeal the law that was passed after the Great Depression to prevent this kind of corruption on Wall Street, where investment houses and banks are put together in a way that brought our country down. These were all bought and paid for with soft money. And that's what McCain and I, working with Trevor, dealt with. but the Supreme Court opened up an even bigger spigot.
These are not simple, easy issues with one answer. If they were, we wouldn't be here. If they were, you wouldn't have 5-4 votes in the Supreme Court going both ways in a 10-year period. Jim Bopp is absolutely right that when an individual who feels passionately gives to a candidate who already has these views because he wants that person to be elected, that to me is much more appropriate in a democracy and much more what the founders intended in terms of the exercise of the First Amendment than when a corporation, which can't vote in the first place, gives money to a member of Congress because they sit on a specific committee or defeats someone because they oppose a trade measure that corporation wants and they think their successor will be more likely to vote for it. To me, you've then moved to a different place where you are indeed having actors, whether corporations or unions, who are seeking a specific economic result out of Congress, what the professors call rent seeking, where Congress has a lot of power, so the players who want to be involved in that, who want either to pass legislation or prevent legislation, who want their tax loophole to remain in place and to make sure their competitors don't get it, they're the ones who then begin to play the game. And what they've discovered is that if you spend money in politics, you can get legislative results. So I think there are two different ends of that spectrum, and the challenge for all of us is where do we find a comfortable place in the middle, and I think the court has gone off one end of that.
So you say the court has gone off one end of that, and you've also said that the FEC pretty much is deadlocked and is useless. The IRS isn't coming in and making any changes either. So at the moment, would you say we're left with no regulation in terms of the amounts of money that are flowing into politics? And I assume you're agreeing with that. So the question is, what can be done? And we started off saying, can Citizens United be overturned if the justices are getting nervous about it, or is it a much longer process?
Well, you know, it can go a number of ways. I mean, yes, the current court could change it. We could have a president elected who would appoint people who would actually make a proper decision on the law in this case. That can happen in the next 4 to 5 years. In the meantime, there's much that can be done legislatively to mitigate or minimize the effect of the decision. The Disclose Act that we just talked about. John McCain and I proposed the elimination of the Federal Elections Commission, replacing it with a real enforcement agency that would not have this kind of deadlock situation. I think that's essential because even if you overturn Citizens United or pass the most wonderful laws in the world, if they aren't enforced, what good does it do? And then at the state level, there are many opportunities, and even at the national level, to deal with some of these issues through corporate governance, through shareholder rights, to question or prevent the expenditure of certain money through shareholder rights that can be initiated. You know, remember, corporations are the creature of government. They're not natural-born persons. State and federal law can regulate what corporations do. So there's a wealth of opportunities there as well, and I think we should sort of use sort of an all-of-the-above approach to try to limit the problems here.
Trevor, what do you think is the most likely path that could actually have some success?
Well, I tend to be an optimist in life. It's useful. Here, I think we may have with the Supreme Court, we may have a longer time span involved, but if you look at American history, the court does not stay out of step with 75% of the country, which is what the polls show on the issue of whether corporations are people, for very long. You know, new justices will in time come along, and they are unlikely to hold that view. If they do, they're unlikely, I think, to be confirmed by the Senate. So we'll see change over time if the country really continues to think this is a mistake and the wrong way to go. In the short term, one of the sort of surprisingly happy side effects of Citizens United is that everybody has started to look at this whole issue of money and politics and how it plays through. There is an incredibly fertile discussion going on now in the corporate world. Law professors, state justices, and others, as Russ said, about what a corporation is, what the role of the state is in giving it rights. The Supreme Court says that it can spend money in elections. Okay, who gets to make that decision? There are a group of people who are saying that corporations and their boards of directors owe it to the shareholders to have a transparent policy that lays out how these decisions are going to be made. Justice Kennedy appeared to say in his decision that if shareholders didn't like corporations, their corporations, spending their after-tax money, which is not deductible, if they didn't like that, they could do something about it. So people who are involved in the corporate world are saying, well, maybe shareholders should be able to do something about it. Maybe corporations should be required to get their shareholders' approval before they make a political contribution or expenditure. Well, that's something, as Russ says, that state legislatures can deal with. So you don't even have to look at a deadlocked Congress to say, well, perhaps legislatures that grant corporate charters or legislatures and states that have corporations doing business there could say, you're welcome to do business here, but if you want to spend money in elections, you need to have your shareholders' approval. And so there really is, I think, a rethinking of some of these underlying issues as a result of Citizens United. That would be one of, I think, many possibilities. The SEC is currently looking at a little piece of it where they would at least require corporations to inform shareholders of how the money is spent in campaigns.
There's also we talked this morning about looking at it from the candidate's point of view, from the people that are getting all this money, in terms of what kind of heavier restrictions on disclosure, for instance, more disclosure ideas put forward, and also when candidates should recuse themselves, particularly judicial candidates, in terms of the large amounts of money that are now coming into judicial elections. What's your thought on that?
I think it's a great area to explore. We were talking this morning about the fact the Supreme Court doesn't even have to abide by its own rules of judicial conduct. It doesn't apply to the Supreme Court. There's legislation that actually would require that in the Congress. But I think as a former legislator that having a much clearer connection between contributions and people having to state what contributions they've gotten in the official record, congressional record, would be great. When I was in the Senate, I sort of played off of what Fighting Bob LaFollette used to do. He used to go around the country and call the roll. He'd take a roll call sheet and he'd go out on a train stop somewhere in the country and he'd tell everybody who voted with the train men and the timber men, and it was quite a show, I guess. He could speak for 3 or 4 hours without a break. I couldn't do that. But I was able to go on the floor of the Senate and 16 or 17 times do what I call the calling of the bankroll. And just go out there and say, we're going to take up this bill now, just so you know, the credit card companies have given this much money, and this company has given this much money, now let's have the debate. And people were squeamish. At one point, Senator Mary Landrieu of Louisiana had it because I was mentioning oil company contributions, and she tried to invoke Rule 19, which requires the senator to be put back in his seat so he doesn't speak, because I was impugning the integrity of the Senate. This doesn't impugn the integrity of the Senate. It merely informs people. So I think it's a fertile area for activity.
Well, let's give some of the audience a chance to not be put back in your seat and join the discussion here. Could we have some questions from the audience? Mm-hmm.
Talk a little about the case, the Montana case.
Yeah, Trevor would be...
Restate the question.
Yeah, the Montana case. Montana has had a law limiting corporate contributions, I don't know, almost as long as, I suppose, the Tillman Act. And so the Supreme Court decision didn't just strike down the Tillman Act. It made a law like that on its face unconstitutional. Montana and its Supreme Court said, actually, it's still good, should still be good law. Naturally, that was appealed by the corporations and others. It went to the Supreme Court, and now they're deciding whether to take it up. Is that correct?
Yeah, the background here is interesting. When Senator Feingold and Senator McCain went to hear the Supreme Court argument, they came out and McCain said, those people think we shouldn't be writing the laws, because it was clear that the conservative justices were saying, basically, we know better than Congress does. Congress is self-interested. Any law they have passed on campaign finance must be an incumbent protection law, and we are the people who are put up here to throw those sorts of laws out. Well, it's a very different view of how our democracy works and the function of Congress that certainly the members of Congress have. And what's happened in Montana is that Montana has a law, it was one of the 26 states before Citizens United, that restricted corporate spending in elections, direct spending. And when the Supreme Court threw out the federal law, they threw out all those 26 state laws as well, which is one reason I think people were really horrified, is that this was an enormous sea change in the twinkle of an eye. But Montana's stubborn, and they decided that they weren't going to get rid of their law. They were sued by the ubiquitous Mr. Bopp, who Elizabeth mentioned, and he said, I represent out-of-state corporations. We want to spend money in Montana because we want to elect legislators who think our way, and we want to defeat legislators who our clients don't like, and your law prevents us from doing this. And the Montana Supreme Court said, Citizens United, that decision said there's no evidence that corporate spending in elections corrupts, and therefore you can't restrict that corporate spending. But the majority in the Montana Supreme Court said, we're different. We have a lot of evidence that corporate spending corrupts. We have 100 years of corporations coming in and doing terrible things to the state of Montana. You know, we have the reason that we now elect senators is that the same corporation in Montana bought a Montana Senate seat under the old system when it was selected by legislators, not once but twice. And the whole U.S. Constitution was changed because of that. So Montana said, since we have all this evidence, we can regulate it because Citizens United allowed us to regulate it if there's actual evidence of corruption. So that case has gone to the Supreme Court. They have asked for briefing on it, and as Russ said earlier, two of the justices in the minority in Citizens United have said, given everything that's happened since Citizens United, this would be a good time for our colleagues to take another look at their reasoning, and maybe they made a mistake. Now, do I really think that anyone in the majority is going to admit they made a mistake in only 2 years? Probably not. On the other hand, there are ways to say, without admitting you made a mistake, there are ways to say, this isn't what we intended. And I think one possible outcome of Montana would be that the court says, you know, we repeat, disclosure is fully constitutional and the spending has to be truly independent of candidates. So they may narrow the way it's played out now.
And if they don't do it this time in Montana, people say to me, well, where are you going to get the cases from? They'll be coming. State legislators all over the country are going to reassert this. States are going to reassert it. There will be cases coming, and give them further opportunities if it's a little too soon to admit they were wrong.
Sure, and I think if there is a state legislature that goes the route I'm suggesting of saying that we're going to require corporate spending to be approved by shareholders, that'll end up in the Supreme Court. And it's not at all clear the court would overturn that.
Let me ask a question that we have from one of our online listeners. Do you believe the move to amend movement is a viable path toward finance reform?
I am pleased that people are using every angle they can think of to put pressure on the Citizens United decision. I am not somebody who's been enthusiastic about constitutional amendments, particularly changes to the Bill of Rights, which have never occurred in the history of this country. I was chairman of the Constitution Subcommittee in the Senate, and I saw some really bad ideas about how to change the Constitution and took pleasure killing those amendments. So my first instinct is to hesitate with regard to changing the First Amendment. I also worry about the proposals, although I think they're ingenious, to try to change the notion of corporate personhood under the 14th Amendment. But other people have ideas about personhood, as we saw in Mississippi and so on, whether or not you want to go down that route. So my answer is, whereas I would have been absolutely against amending the Constitution in the past, I still am not persuaded it's a wise course, but I welcome everybody who wants to pursue that route to the effort. We can have different views about how to solve this problem, but the energy behind Move to Amend and the other constitutional amendments is invaluable in building the kind of public reaction that Trevor has mentioned.
And how likely do you think it is that ultimately these changes will be made by an amendment or more by legislative changes either from Congress or by the states?
It's much harder to make change by a constitutional amendment. That's why we don't have very many, particularly on highly controversial issues, where you have a huge consensus, something like the 18-year-old vote. It can happen pretty quickly. But on a subject this contentious, I think it's much more likely we will see it through a combination of congressional action, administrative action, action in the states, changes in the court, composition of the court than we will through a constitutional amendment. But I agree with Russ that I think the energy that goes into having those conversations is useful in goosing Congress to come up with other answers, because they're not keen on a constitutional amendment either. But this pushes them to do some other things that could be done.
One of the only amendments I ever supported, actually, was to not let governors pick senators when there's a vacancy.
Oh.
Quiescent.
I think we need that one. No, it was after the
We've
fact.
heard something about that. All right, another audience question?
There's one here.
Right back there. So what do you think about money pouring into groups like Allies?
Oh, Alec.
What do you think about money pouring into some of these groups that are?
Well, this has to do with ALEC, which is
Right.
a very conservative group that basically drafts model legislation on the conservative side, sort of ready-made, just heat it up and bring it to your state legislation that does everything from take away people's collective bargaining rights to taking away people's right to vote without having an ID. ALEC is a very disturbing phenomenon. It has to do with not just the nationalization of American politics, but the corporatization of American politics. You know, we took great pride in Wisconsin, and I think you did here in Illinois, that each state was a laboratory for democracy, that we had our own ideas, that we would look at what other states did, but we wouldn't adopt hook, line, and sinker the same language from some group funded by the Koch brothers. That's what ALEC is. And it has done great damage to our state by tearing a horrible rift within our state through its desire to crush public collective bargaining by public employees.
I think part of the answer to that is, again, more disclosure. People have a right to lobby the legislature. That, too, is part of the Constitution. And if people want to come up with legislative suggestions, great. But it shouldn't be in secret, that you should know where the funding is coming from. The group should be public about what their proposals are so that people understand where they're coming from and what the agenda is.
So some of that public outrage, I think you've seen building as you've gone across the country.
Well, I'm occasionally asked, somebody says to me, "You're a serious lawyer. Why are you doing this late-night Colbert show?" And my answer is exactly where the questioner was heading, which is we need to have people who are engaged, who understand what the issues are, and will be moved to act. And, you know, those of us who care about these issues already get a lot of news from NPR. But you want to reach different audiences. And the totally different audience that is watching the Colbert Show ends up understanding issues better, becoming involved, and that's what we as a society need. We need more civic engagement. It is far too easy for people to just turn it off and to say that's someone else's problem. You see that in our voting rates. It's a tiny percentage of the country whoever actually gives to a candidate of even $100 or something. It's less than 1% who are contributing to candidates. So we need more involvement, and it seems to me that that is the check you then have. If people know what their legislators are doing, that's incredibly helpful. The slight off-track digression, but one of the issues I think you see in Washington now is that newspapers used to have major Washington bureaus, and those people reported logically on what the representatives from Illinois were doing in Washington. Increasingly now, those bureaus aren't there. It's, they're relying on the AP or someone else, and it's very hard to have someone who will dig into what your local congressman is doing, how they're voting, where they're traveling, where their money comes from, what they're saying, because that focus isn't there with the loss of local news on the
Absolutely.
newspaper side.
Let me ask one final question, and this is sort of a very basic question from a viewer. If the Supreme Court has declared corporations to be people able to give money, will corporations be able to vote?
Well, that's the absurdity of the decision. Corporations can't vote. There's a guy in Maryland who said he was going to run his McDonald's as a candidate. Why not? What's the rationale here? In fact, I thought it had to be a little embarrassing for the Chief Justice Roberts, who shortly after Citizens United wrote an opinion in the AT&T case where he mocked corporations because they had asserted a right to privacy. He sort of laughingly said, no, they don't have a right to privacy. Well, right, why not? If they are people too and have a right to give unlimited contributions from their treasuries, it isn't a logical portrayal of what corporations are. In fact, the opinion of the court, I think, is very questionable in suggesting that the founders of the country had this belief. I mean, corporations were chartered by the government directly at that time. So obviously, I don't think they should have a right to vote, and I don't think they should have a right to give unlimited contributions.
This is in some ways an interesting philosophical question, because if you watch the court debate in Citizens United, justices like Scalia in particular, and Alito and others who ended up in the majority, clearly to them, corporations meant individuals, not just our corporations people, but they were talking about the corner barber or the hairdresser who incorporates, and all their examples were individuals who happened to use this corporate form. The other side was talking about, you know, humongous international entities. So there was perhaps a crossing in the night of who they were thinking of. This is a group that, you know, I assume you're in downtown Chicago, you have lots of corporate connections. What I find when I'm talking to corporate executives that illustrates why the court was wrong in Citizens United is that if you talk to senior executives about where they give their personal money, how they vote, what they think ought to happen on national policy, whether it's taxation or local education or anything else, they have strong views, not surprisingly, fairly diverse because they're citizens, they have children and grandchildren and a stake in society. If you talk to them in their capacity as a corporate executive and you ask them how they should do things in the best interests of their company, you get a very different answer. It's a much narrower answer because corporations are supposed to make money for their shareholders. They're not supposed to worry about all the other things that make a civic society. And so what we've done here is we've told corporations that they should spend their money on their single narrow interest, which is how do I keep my tax break, how do I get my taxes down, how do I get an advantage over the other competitors. And that's, you know, to me, that's a real problem in a democracy where voters and those executives wearing their citizen hat have much broader concerns.
And in truth, have all these contributions that have rolled into these super PACs come from corporations, or have more of them come from an individual like Stuart Abelson?
They only so far about 20% appear to be from corporations. So some people say, aha, it's not a corporate problem. Well, wait a minute. If you're a corporation, you don't have to give to a super PAC. As we've explained, there are other ways for you to affect the election by giving to the Chamber of Commerce so that nobody knows you gave, giving to these C4s. So what we're seeing is the corporate money that doesn't want to be disclosed because they don't want angry shareholders are going where they don't have to tell who the donors are. And the super PACs, which by and large disclose their donors, are therefore more individuals.
Plus, I believe a fair amount of this is privately held corporations. People that control their own corporation, they're not, won't have the same requirement as publicly held corporations. So very wealthy people, I think such as the Koch brothers and others, can use that kind of an approach too. You can't just look at public corporations in analyzing this.
Well, just finally then, to wrap it up, you said you were by nature an optimistic person. How optimistic are you about campaign finance reform?
I'm also a realist, which means only things
that.
take time. I am optimistic that with conversations like this and people really thinking about these issues, as I said at the start, I talked to Republicans and Democrats. They have different solutions, but they don't like where we are. So I think we're entering a period of real ferment where we're going to be talking about what needs to change. There are a lot of options out there. There's some we haven't had time to talk about today, like the idea of vouchers to help candidates get money or television time or tax credits for people to encourage them to fund candidates privately. There are all sorts of things that I think we will see coming out over time.
I'm an optimist by nature too, and I am absolutely confident that this system will not survive. It will fall of its own weight. John McCain is right, as he almost always is, because we used to have press conferences every year. Reporters would laugh at us. They'd say, well, why do you guys keep trying to do this? It'll never pass. And John would always say, there will be a scandal. And of course, there always was a scandal. And there's going to be a big scandal here when people finally reveal the kind of conversations that are being held. So I think this system will fall, and I think it might be sooner than we would expect.
All right, well, gentlemen, thank you very much. And if all of you didn't quite understand what we were talking about, go to YouTube and bring down Trevor Potter's conversations with Mr. Steve Colbert, and you will understand it perfectly.
And it'll be funnier.
That's true. Thank you very much.
Thank you. Thank you, as always.
My name
Thank you,
is-
Elizabeth. Good
Got
job.
it. Thanks a lot.
My name is Nancy Stevenson. I'm the president of the Stevenson Center on Democracy. And I want to point out that there are many people here with us today who've made their life interest reform of politics and government. And we thank them. And we thank the people online and on air. The American Association of State Colleges and Universities has made classes across the country that are listening to the program that we've just listened to in this room. I want to thank all of the people who are here with us to hear this extraordinary conversation. Elizabeth, with your research and probing questions, you give us facts and understanding, and those are the tools of good government. And for the two of you who've come from afar, Senator Feingold and Trevor Potter, we thank you for sharing your optimism, you both are optimists, and your belief that indeed an engaged public will make a change. So we are grateful to all, and thank you so much. The meeting is now adjourned.
Thank you.
But before the audience in the room leaves, I want to remind you that Senator Feingold has his book, While America Sleeps, that he is willing to sign for those who step up and purchase the book. It's the Seminary Co-op that's selling the books, and that's a great independent bookstore. Thank you all.